shit, let me pop it. Spend too much time in the cell sitting idle. Try black suicidal, and I put that on the Bible. I wasn't having shit, niggas was passing me, looking back at me like I ain't shit. Now I'm the shit, and this that shit, and whenever I spit it be turned up lit, it be turned up lit.
So, what was said yesterday was the amended rule. I don't know if this was said yesterday, but I believe this is what Verb is talking about. Says the amended rule 30 of section 202.70G of the rules of practice for the commercial division requires the parties to participate in a mandatory settlement conference. The parties are directed to meet and confer regarding the mandatory settlement conference and promptly e-file a letter updating the court as to whether the parties will proceed with a private mediator or if the parties would like to avail themselves of the court's ADR program. This doesn't say that the judge urges. This is just saying that they need to be a part of this meeting. It's a mandatory meeting. It's a mandatory settlement conference. It don't necessarily mean that they have to settle. It don't. So I need to see what Verb is talking about. Maybe he got different information. But Norbes is asking to settle for $15 million. And here's that right here. Hold up. I think. So the nature of action of the actual meeting, the proceed is for contract, and the amount demanded is $15 million per Norbes. Per Norbes. That's just saying that they have to go to this Let's go back to it. They have to go to this mandatory settlement conference. And they got to update the court if they want to do it privately or if they want to use the court's ADR program. Now, if they use the court's ADR program and that's public, I don't think they settle at all. If they go private, they might settle. They might ask Google. Ask Google. Yeah, let's ask Google. All right. Let's see if that is. What is this shit called? The mandatory settlement conference. Do people have to settle in a mandatory settlement conference? Let's see. While it does not happen with every case, it is possible to settle all issues that make up divorce at a mandatory settlement conference. I don't know where it says divorce. If your case happens to settle at the MSC, it is very, very important that your attorney write everything down that was discussed while you are still at the courthouse. So it says, hold up. If your case happens to settle at the MSC, so it is still a case that this mandatory settlement conference that is not settled. You have to attend the trial counsel. Parties and persons with full authority to settle the case must personally attend the conference unless excused by the courts for good cause. If any consent to settle is required for any reason, the party with the consensual authority must be personally present at the conference. What does mandatory settlement conference mean? A mandatory settlement conference is an opportunity for all the parties involved in the dispute to come together to try to resolve the issue without a trial. Trials are long and expensive and emotionally taxing. It is in the best interest of everyone involved to avoid a trial if possible. It means that they have to attend the conference. They don't have to settle. Boom. There we go, Jules. I appreciate it. I think mediation, and I said meditation. Mediation? No, that's meditation. I know how to read sometimes. You feel me? I think mediation and civil suits are mandatory to try to resolve outside of court. You're missing the key word, civil. And it means they have to attend the conference. They do not have to settle. Are mediations mandatory in civil lawsuits? Shit, I don't know. I don't know. But so this is just something that you know what I mean? I don't know if it was requested. I don't know who is requested by though. On September 27, 2023, the court held a status of conference via Microsoft Teams with counsel for all parties present. A notice of the issue was filed in this case on August 11, 2020. During the conference, the parties indicated that defendants intended to file a dispositive motion within 60 days of the filing of the August 14, 2023 filing of the notice issue. So somebody brought up an issue. A note of the issue was filed in this case on August 11, 2023. Who filed this issue? A notice of issue was filed. Who filed the note of issue? Was it Norbes? It would have to have been Norbes. During the conference, the parties indicated that defendants intended to file a dispositive motion within 60 days. What the fuck does dispositive mean? I think we might have learned of this, a new word. Dispositive, relating to or bringing about the settlement of an issue or disposition of property, such as litigation. All right. Dealing with the disposition of property by deed or will. Dealing with the settling of international conflicts by an agreed disposition of disputed territories. So basically, they're filing for disposition, basically. They want to reconcile. But that isn't necessary. That isn't, I don't think that's the URL that wants to reconcile. That's not. A note of an issue was filed in this case on August 11, 2023. During the conference, the parties indicated that the defendants intend to, that the defendant, who is the defendant? Who is the defendant? The defendant in this case would be the URL. So the defendants intend to file a dispositive motion within 60 days of the filing of the August 14, 2023 filing of the note of issue. Now that's interesting. Now that is interesting because we just learned that this positive motion means that they're trying to have disposition. They're trying to reconcile. Related to or bringing about the settlement of an issue or the disposition of property. Norbes is the plaintiff. Okay. There's a motion seeking a trial of court order entirely disposing. Oh, whoa. I got this fucked up. My bad, y'all. It's right here. I got this fucked up. It's right here. In law, a dispositive motion is a motion seeking a trial court order entirely disposing of all or part of the claims in favor of the moving party without need to further trial court proceedings. To dispose of a claim means to decide the claim in favor of one or another party. So they want to completely dispose of the claim. Thank goodness for Google. So the plaintiffs, the defendant, which is the URL. Now we getting somewhere. Got to read the whole thing for context. Y'all know I'm a little slow. Just a little bit. You know what I mean? I'm on the spectrum a little bit. Y'all bear with me. So this makes more sense now. A note of the issue was filed in the case on August 11, 2023. During the conference, the parties indicated that the defendants intended to file a dispositive motion within 60 days. So within 60 days, they're going to file this motion to say, hey, we are trying to dispose of all are part of the claims in favor of the moving party without further trial. So they're not even trying to go to trial. We trying to get this. Look, dispose of that shit because that shit ain't what it is. And we're not trying to go to court with it. You know what I mean? So the sport within 60 days. So URL was the filer of the note of issue. I wonder what the issue was or why they filed it. What was the issue? The amended Rule 30 section, then we get back into this. The amended Rule 30 section of 202, blah, 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 of the rules of practice for the commercial divisions requires the parties to participate in the mandatory settlement conference. The parties are directed to meet and confer regarding the mandatory settlement conference and promptly e-file a letter updating the court as to whether the parties will proceed with a private mediator or if the parties would like to avail themselves of the court's ADR program. Sheesh, it sounds like they're trying to get the case thrown out. That's exactly my sentiments, Jules. That's exactly, or not my sentiments, but that's exactly what I'm thinking. You know what I mean? I would have assumed you was high. Twin, I'm slow. I'm a little slow. I do be high sometimes, but I'm a little slow too. Oh shit! They want to focus on the RBE case. That may be a fact too. That may be a fact too. So a follow-up status conference is scheduled. So they're going to have this conference somewhere between now and November 8th. Because it says on the follow-up status conference is scheduled for November 8th. The follow-up status conference. So I guess that's the status of the conference. I'm not sure. I don't know. It's scheduled for November 8th. So I guess November 8th, 2023. We'll see. Only if the battlers use Google for their contract. Yeah, if the battlers was to use Google for some of this termination, you see how we got to the bottom of that shit right there. You know what I mean? Look, I'm not the smartest nigga ever. You know what I mean? But shit, once you find out what words mean and shit like that, a dispositive motion is, nigga, we trying to get this shit thrown out with no trial, no nothing. Yeah, we can go to this shit. You know what I mean? But that's probably why Norbes is trying to, you know what I mean, trying to push for this this mandatory settlement conference. Because he sees in the law, but it's like, hey, this is mandatory. You guys got to come to this, whatever. But these niggas was like, yo, in 60 days, we filing for a motion to have this shit thrown out, my nigga. Like, oh, hey, yo. But then, I guess here's the motion right here, or part of the motion. The nature of contract proceedings, or the nature of action or proceedings. And this is for a contract, and the amount demanded is $15 million. I get it. The original amount was what, 80 million? So going into this meeting, the amount demanded is 15 million. And this is from Norbes. This has to be from Norbes. You know what I mean? This has to be from Norbes. Smoke out of them for law and order. Damn! I want to see what the fuck Averb is talking about. Where the hell is Averb talking about? Started at 40 million, went up to 80 million. Now you're talking 15 million. That's what I'm saying. And I want to read this too, what she got up here. I want to have the understanding for self. It says, all right, a note of issue was filed in this case with a jury demand on August 14, 2023. That doesn't mean the jury demanded it. That means they demanded the jury. Don't that mean, like, let's see what a jury demand is. Fuck it. What is a jury demand? A jury trial or a trial by a jury is a legal proceeding which is... All right. What is a jury? What does jury demanded by mean? Any party who timely serves and files a jury demand. So it's a party who files the jury demand. It's not something that's demanded by a jury. I just knew that didn't sound right. Jury can't demand shit. They're supposed to sit there and listen and deliberate. That's it. That's it. I'm glad we got Google. Shout out to Twin. The filing of the note of issue triggered. So it was one of the parties. So it was Norbes. Filing the issue trigger required that the parties participate in the mandatory post-note issue settlement conference. That is filed by Norbes and his people because of the fact that URL and their people was filing for a, what is that shit called that we just said? A dispositive motion, which means they was filing to get this shit thrown out within 60 days. So Norbes countered and did this. Said, no. We still have a mandatory conference to go to, buddies. Let's go to this first. You know what I mean? That's what is being said right here. It's not that the jury demanded. It's that Norbes' lawyer put in, serves a file a jury. You know what I mean? A party who timely serves a file a jury. You know what I mean? And pays the required fee entitled to the jury unless prohibited by a statute or contract. That's what it says right there. You know what I mean? The settlement conference can be, once again, you know what I mean, done privately or with the court's ADR program. I'm just saying, like, look, Norbes wants a private mediator because it's cheaper. You ain't got to go through the court costs and all of that shit, right? It is what it is. They just saying, like, we don't care. We're gonna file to get this shit. We're filing for a dispositive motion at this point. We're filing to get this shit out of here. We'll go to your little mandatory meeting. We don't care about that. We'll go. We don't care if it's with the courts or whatnot, because at the end of the day, if it's found that you wasted the court's time, you're going to have to pay these court fees, sir. I don't believe we have a strong preference one way or another. If the plaintiff prefers a private mediator, we're certainly open to that. We haven't previously discussed with them. Okay? Why does that make him dumb? The court, all right. Well then, you'll discuss the selection of the private mediator, and I can be one of the mediation. Okay, well then, you discuss the selection of the private mediator. It can be one of the mediation platforms like Jams, or if you're so inclined, I could recommend mediators who have been extremely successful in resolving cases that I recommended these gentlemen mediate, and the parties agreed to have them mediate. That's not saying that he recommended that the URL mediates. That's saying that he's recommended mediators to other people and have them mediate. Let's read that again. Maybe I'm missing something. Or if you're so inclined, I can recommend mediators who have been extremely successful in resolving cases that I've recommended these gentlemen to mediate, and the parties agreed to have them mediate. That's not saying that he's recommended URL to mediate. That's saying that he's recommended mediators to. Oh my God. All right. The reason why is because this is a mandatory meeting. This is a mandatory meeting that happens for any commercial litigation. It's a mandatory meeting. It does not mean that you have to settle. I want y'all to remember that. Let me ask whether there are going to be any dispositive motions in this case. Mr. Bagley, yes, Your Honor. And dispositive motion means that they want this thrown out. They're going to have all of this shit thrown out in this position, right? This is Ross Bagley for the defendants. We intend to file a motion for summary judgment on the date 60 days from the deadline from the note of issue, which is October 13th. We intend to file a motion for summary judgment. What does that mean? A motion for summary judgment. arguing that they're entitled to a judgment in their favor without a trial. That's all that means. It doesn't mean money. They're only arguing, they're filing for the motion for summary judgment. And this is Mr. Bagley. He represents the URL. We intend to file a motion for summary judgment. And a motion for summary judgment means that they are entitled to a judgment in their favor without trial. So they're filing for a motion of summary judgment they're filing for a motion of discovery judgment. What the fuck is that? For the URL. How the fuck? Mouthful. Like it got a little. Oh no. Might need to go get some water. But we intend to file a motion for a summary judgment. That means they intend to file for this to be thrown out in the 60 days from the deadline of the note of issue. And the note of issue was from the plaintiff, which is October 13th.
All right.
Okay. So they have 30 days from the judgment to file. So, and then they're saying like, listen, we'll do that. So just to give y'all a summary like of what I understand, the URL wants to file a motion. You know what I mean? What do we call this motion? I forget what we call this motion. Yeah, I'm all over the place. A dispositive motion, and this motion means that basically they're seeking to throw this shit out. You know what I mean? Without going to trial type shit. You know what I mean? But Norbes is saying no. This is not what we're doing because it is a mandatory conference that needs to happen. With all commercial litigations or whatever proceedings and shit like that, it is a conference, a mandatory conference that needs to happen, and we're filing for this motion. So we need to all come to this conference. URL says again, okay, you can file for that motion. You can file for that motion all you want, but we have the same right to file this disposition or this positive motion to have shit thrown out in our favor. You know what I mean? And the motion, we can file for a motion of summary judgment, which means that they are entitled to a judgment in their favor without trial. It does not mean that they have to go to this meeting with a figure in mind. It does not mean that they have to come out of this meeting with the settlement. If it happens, it happens. Fine, good, great. That's what it is. You know what I mean? But if it don't happen, then guess what? In 60 days, the URL is going to file for their motion for summary judgment in their favor. In their favor. And they're filing and they want this dispositioned. They want this thrown out without going to trial. So I'm gonna be real with you. If nothing happens in that, we might see this case thrown out. We might. I'm not sure. I don't know. Y'all tell me what y'all think. Y'all think it's gonna be thrown out, or y'all think that they gonna settle with Norbes?
My ace is polar, I can't control it. Hella bright motor, still driving slowly. Yeah, Ratatouille done ran into a cobra. Yeah, my nigga smoker really smokes on. Rio, the great Bambino, money like a phone number.